Hey, you guys. Hey, everyone. Welcome back to my channel. I hope everyone's having a great day. So let's get into, you guys, the latest news in regards to the Lori Vallow Daybell trial case, whatever. So as you guys know, Lori Vallow Daybell, she is known as the Doomsday Mom, the cult mom. She has been accused of unaliving her children, Tally Ryan and JJ Vallow. The two vanished back in September 2019. And it came out, their bodies were later found on the property of Lori Vallow's new husband, Chad Daybell. We can go through who everybody is, but I feel like if you're watching this, you probably know who they are. If you're on the live chat with me right now, make sure you change your chat from top chat to live chat so you see the most recent comments. If you're watching on playback, I don't think you have to do that. Hopefully the comments will show up for you guys. So let's get into this, you guys. I have heard about this case, but I really didn't know about this case. A while back, I watched the Netflix documentary, I think it was, to kind of get more familiar with this case because I wanted to start covering it. I feel like so many people cover it, though, that I don't know if it would make sense for me to cover just because so many people cover it. But either way, let's get into you guys. I was actually sent some emails today about this newest ruling in the case. So because of the charges that Lori Vallow is up against, the unaliving of her two children, that is capital unaliving, and you can face the DP. Also, you guys, I have to be very conscious of the words that I use because YouTube has really gotten bad about limited ads, demonetizing my videos because of the language and the titles and things such as that. So I'm trying very hard to make sure I don't say certain words. Also, I have a banner that I'll put up every once in a while, just kind of reminding you guys. It says, please do not use certain words that could potentially demonetize this video. If your comment contains certain words, it will be deleted. And don't think we're mad at you, though. You know, we'll just delete the comment and say, hey, we had to delete that because of some of the language. We're not mad. I've never been this type of channel before to delete comments because of the language, if it said the M word or anything like that. But because YouTube has cracked down on me for sure in regards of it, I am trying to do better. So anyways, let's get into this. Someone actually sent me this video and it breaks it down really well as to why the judge made this ruling. Why would the judge take the DP, the unaliving penalty, off the table for Lori Vallow? This is a she committed capital unaliving, so she should face capital punishment. But Nate with East Idaho News, he breaks down what exactly happened. So we're going to let him explain it because I'm no lawyer. And yes, Mariska, it is all of YouTube. It's not just me. So any channel that you're on, honestly, if they allow you to use that language, their video could be demonetized. So just be conscious of that. Yes. All right, so let's listen to what he has to say. He breaks it down in a way that even I could understand, you know.
Good afternoon, everybody. I am not in Idaho, as you can tell. I am in Virginia on spring break with my family. I thought that I would get in a quick vacation before the Lori Vallow's trial starts in a few weeks. And of course, there's news. And I know many of you, I put out earlier, thanks to my colleague, Rhett Nelson, he was in the courtroom this morning when Judge Boyce ruled that the death penalty will not be on the table any longer for Lori Vallow. And so many of you have been messaging me, texting me, emailing me saying, what exactly does this mean and what happened? And I listened to the court recording, and basically it all came down to this last minute evidence that the prosecution turned over to the defendants, and the fact that the mitigation specialist on Lori's team said that she simply would not have enough time to process all of this. So let me back up and kind of explain all this. When it's a death penalty case, the bar is much higher. And if the prosecution does go for death, then a mitigation specialist is assigned or joins the defense team. And that person is to basically advocate, find everything that they can about the defendant, in this case, Lori Vallow Daybell, and present the case as to why she or he does not deserve death. It's basically their advocate. So they do a whole life deep dive from the time that they were kids. They do interviews with people. They do all sorts of stuff. And then if the defendant is found guilty by the jury in Idaho decides if the death penalty should be pursued or life in prison. And then you go into the sentencing phase. And that's where witnesses would take the stand about why the defendant does or does not deserve death. So what happened was last week, you may recall, the mitigation specialist on Lori's team said, we just got all this evidence. Well, the attorney said, we just got all this evidence turned over from the prosecution. There's so much evidence here. We don't have enough time to go through it all.
So to catch up really quickly, he breaks it down in layman's terms, but just to break it down a little bit more. So when it's a DP case, they have to have certain lawyers, like Brian Kohlberger. The Brian Kohlberger case, his attorney, Ann Taylor, she is a DP attorney. Any case where the criminal or suspect is looking at the death penalty, the unaliving penalty, I don't know, they have to have an attorney who is qualified in DP cases. So like Brian Kohlberger, his attorney is qualified in DP cases. And they may have to have more people. I'm not sure. He's saying mitigating officers, I think is what he said. I don't know if that's the lawyer still or if it's someone else. But either way, like he said, they are the advocate for this person to try to paint a picture of why this person does not deserve to be unalive despite their crimes. Like, oh, they're still a good person despite their crimes, whatever. So Lori has this person on her team, on her defense team. She has this person. And her trial is about to start. And the prosecution has sent over all of this evidence that this mitigating officer has to go through. But it's so much that the mitigating officer does not have time to go through all of it. And by law, they have to be able to go through all of this. They have to. And if they don't have the time to do it, then certain things have to be taken off the table. So I'll let him go ahead, and I hope that makes a little bit more sense if you didn't get what he was saying. But let's continue.
And because Lori Vallow has not waived her right to a speedy trial, this trial has to start. Chad has waived his right to a speedy trial. So they can deal with that down the road. The judge had Lori waived her right to a speedy trial. Judge Boyce could have said, all right, we'll just continue the trial. We'll give the mitigation specialist more time to go through all of this. But because Lori had not done that, the judge had to do something. So the argument was, do you disqualify all this evidence that the prosecution turned in on the day of the deadline? So the deadline, the judge said all evidence must be turned over prior to February 27th, but the prosecution turned things over at 4:00 on the 27th.
Wow.
So do you toss all of that out? That's a significant portion of evidence. Do you toss out evidence that came in after that? Because there has been stuff after that, including jailhouse calls from Chad. Do you toss that out? And the judge went through this all as he was explaining his ruling this afternoon. And the judge made it very clear that the prosecution, in his eyes, has not done anything wrong as far as, intentionally misleading the court, and that Jim Archibald has not done anything wrong. He said that he's worked with both parties multiple times, multiple cases. I think he even said hundreds of cases, and stuff like this has not happened before. In fact, Jim Archibald even said he's never had this issue with the prosecution before, except in this case. The prosecution has said it's because there's so much evidence. And they're continually getting it. And so it all came down to, what do? Do you go forth with the trial and you have a mitigation specialist who says, okay, I wasn't ready, but I didn't have enough time to do all this. And then if she's sentenced to death, you have issues on appeals, or do you toss out the death penalty? And that's why Judge Boyce did it. He simply said it came down to that. This last minute evidence, because the bar is so much higher, it'll make the case, I don't want to say easier, but it won't be as laser focused on certain things. So death penalty is out for Lori Vallow. There were a couple of arguments.
I do want to stop and commentate on it just to make sure it falls under fair use. But another thing too that he said is that the prosecution had to turn all their evidence in by like February 24th, 4:00. And they turned most of it in February 24th, 3:00. And then turned in some evidence even after that. So there's all this evidence that the prosecution couldn't even turn in for a long time, couldn't send over to the defense because it took them so long to go through it. But the defense is not going to have equal amount of time to go through this evidence. I mean, the prosecution has had it for a long time to go through it, which it's a lot. It's a lot to go through. And that's what they were saying. Like, it's a lot to go through. That's why it's taken us so long. But they turn it over to the defense at the last hour of the last day, and even some of it afterwards. So the defense is not going to have the time, and the mitigation officer is definitely not going to have the time.
Other arguments that Lori's team made, such as media coverage and the fact that the death penalty is unconstitutional or should be unconstitutional, and the fact that currently in Idaho they haven't put anybody to death recently because they can't get the drugs for the lethal injection. In fact, interesting side note, the Idaho legislature just passed a bill to bring back the firing squad, and it's on the governor's desk as we speak. So if you can't get the lethal injection drugs, you could die by firing squad. And the state has waited to execute somebody for, I believe it's been postponed 2 or 3 times lately because they can't get the drugs. So anyway, that's a side note. So the judge, really, his main focus on arguing this was, or on issuing this opinion, was saying, listen, the mitigation specialist isn't ready, and this last minute evidence keeps coming in, and I can't postpone this trial any longer, or else it'll violate her right, Lori's right, to a speedy trial. So
yeah, Lori waived her right to a speedy trial. Chad Daybell did not. So her trial has to start soon. And because the defense did not get this evidence, it's so much evidence they wouldn't have time to go through it. And the mitigation officer has not been able to go through it. They feel like they can't represent her properly on a DP case.
So that's what's going to happen. So now the trial should be much shorter because you won't have that sentencing phase, and jury selection will be shorter, I would imagine, because in jury selection, they were going to have to get into deep death penalty issues, ask all potential jurors, do you believe in the death penalty? What are your feelings about the death penalty? And if any of them said, everybody should be killed or something like that, they're going to be disqualified. Well, now they don't have to go there. So I imagine you'll see the case will get started, as far as opening arguments, that'll get started sooner rather than later. And once the jury comes back with a verdict, if the verdict is guilty, previously, they would have gone right into the sentencing phase. Excuse me. That could have lasted a week or 2, where there's witnesses and there's experts and all of that. And then the jury would have come back and said, life in prison or death. Well, now, if the verdict comes back guilty, the judge will impose the sentence. And it probably won't happen right away. The judge will what happens in other cases that I've seen is if there's a guilty verdict, the judge then orders a pre-sentence investigation. And so everybody goes home. Lori won't go home. She'll go back to jail if she's found guilty. But and then 2 months later, a month later, 3 months later, whatever it takes, the judge then comes back and the sentencing is issued. And she very well could be sentenced in Fremont County, back where the alleged crimes were committed. So that's kind of how it works. Now that the death penalty is off the table, trial could be shorter. The sentence, we won't know right away. It'll be down the road a little bit, most likely. As far as Chad still is facing the death penalty. And many of you are asking, does this apply to Chad? Are they going to take it off the table for Chad? At this point, no, because he has more time. Now, his attorney could obviously file a motion and say, yeah, get death penalty off the table for him as well. But that will take some time. We're still waiting on a trial date for Chad. We don't know when that will be. Could be later this year, could be next year. He could take a plea agreement between now and then. We'll just have to wait and see. Many of you asking, what was Lori's response? Rhett, my colleague, was in court. He obviously couldn't see her because everyone sits behind her. He couldn't see if she smiled or anything, but we did get video of her leaving that I posted here. And she seemed to be behaving her normal way, kind of a smile a little bit, did not look distraught or disturbed or anything. But, there's that. That's how she looks. So a big development today. The other issue was, will the judge admit this evidence that came in on that technical day after the deadline? Excuse me. He said that he's going to issue a written order by tomorrow and see how that goes. But again, he did not fault either side. He didn't fault the prosecution. He didn't fault the defense. He doesn't think that they're acting in bad faith. It's just simply that the evidence came in late, and there's a lot of evidence in this case. So I hope that makes sense. Somebody just asked, where are you in Idaho? I'm not in Idaho. I'm in Virginia. And I actually used to work here in news. So many of you know me from TV8. It's great to be back here. Been seeing a lot of people that we know, and I've randomly run into some old sources. I do want to mention, I posted earlier, many of you may have seen that Tammy Daybell's parents, Ron Douglas, submitted a request to Judge Boyce that they be able to watch the trial remote. They live in Springville, Utah, several hours away from Boise, and Ron's wife Phyllis is not in the best of health. Wonderful couple. But it's hard for anyone really to go sit in a courtroom for 8 hours a day for 6 to 8 weeks. And so he asked if there would be some way to get a remote camera to their house or something, and the judge said no. The judge denied that. So they want to see it. They're gonna have to go up there. I know you all are asking. There are no cameras in Lori's case. Chad's case, as of now, there are still no cameras. We'll wait and see. We'll request it most likely after Lori's case is done. It'd be great to have the camera in there. And we'll still request maybe for sentencing, because that's a whole separate phase. But as of now, we're working on getting a sketch artist in there, and we're working on posting audio every day. We just posted the audio. If you want to listen to the judge's ruling, it's about 40 minutes. Go to the East Idaho News YouTube page, and I'll post it here in a bit. Go to that page, and you can listen to the whole thing. He lays it out, why he's ruling the way he ruled, why the death penalty's off the table. You can, leave your comments there and let us know what you think. So again, big news today in the Daybell and, YouTube page, and I'll post, and we're working on posting audio every day. We just posted the audio. If you want to listen to the judge's ruling, it's about 40 minutes. Go to the East Idaho News YouTube page, and I'll post it here in a bit. Go to that page, and you can listen to the whole thing.
I know he tagged it, but I'm not seeing it. Let me see. I know he tagged it. See if we can find it.
Women are taking the lead on screen and behind the camera.
Nope. Okay, let's go back.
Good afternoon, everybody. I am not in Idaho, as you can tell. I am in Virginia.
All right, I'm gonna wait for that tag to pop up because I do want to listen to that audio. It's going to be a long one, so we probably won't listen to all of it, but I do want to listen to some of it. But it does make more sense listening to him say, the way that he's saying it. Basically, the evidence had to be turned in by set date, set time, which most of it was, but it was the last hour of that day. And then some of it was turned in afterwards. And because there is so much evidence, the DP officer who represents Lori Daybell, because it's a DP case, she is unable to go through all this evidence. So the only thing they felt like they could do to make it kind of fair was to take DP off the table. It's like he said, it's a much higher bar. A lot more is at risk. Somebody spending the rest of their life in jail or being unalive due to a DP. You know what I'm saying? I was hoping he would have tagged this, or he would have put it in the description box. I was hoping he would have put it in the description box. Somebody said Uncivil Law has it. Thank you. Okay, I kind of got confused. Okay. You have the right to a speedy trial, meaning if you waive your right to a speedy trial, you have a speedy trial, right? If you do not waive your right to a speedy trial, the trial could be God knows when. Thank you, Bossy. I'll have to find it on Twitter and email it to myself because I don't think I'm. Just found it. Just found it. Wait, this is 2 days ago. This is court hearing audio from. Okay, that's the wrong one. Why can I not find these ones? I'm confused. All right, let's back it up. Wrong one. All right. Boom, shakalaka. I get confused by it. I get so confused by it. Like, if you waive your right to a speedy trial, that means you do or you don't get a speedy trial. I'm confused by it. In the US, we have the right to a speedy trial. If that right is raised, we can take their time. If that right is raised, they can take their time. Chad waived his right. Her right to a speedy trial is why no TP. Right. So that means she waived her right to a speedy trial. No, Chad did. She did not. So she was going to get a trial quicker than he was. Why does she always look so happy? Why does this woman always look so damn happy? Like, you kilt in a dress kilt that you wear with, if you're Irish. She unalived her kids. I swear she does that to like people. Like she's living her best life. If you waive right, defense is one of the carry of pain. Most criminals do that. If you don't waive your right, it has to be tried sooner. But in this case, thank you, Haunted Haley. In this case, it helped her. Like, I mean, I think if it was me, I know Boom Shakalaka, I haven't heard that in a long time. I'm working on using not saying certain words. You know, if you guys can, the kilt that she wore because she was Irish on St. Patty's Day, as you guys can tell. Yeah, well, I guess she didn't unalive them. She had her brother do it, but she planned it. She said they were evil, basically. Yeah, and not just her two kids, but her ex-husband, her brother, Chad's wife. I mean, my goodness. To waive something is basically to get rid of it or to excuse it. Thank you. I always get it. He waived his. She did not. Is that right? She waived his. Okay. I'm clearly not no lawyer, you guys. Not no lawyer. Let's go back because I want to watch. That's 40 minutes, so I don't think I can do that. But
it's always been inside me to make things.
I do want to listen to some of it.
All right, we'll be on the record. This is KCR 22-21-1624, State versus Lori Noreen Vallow. Representing Ms. Vallow is Mr. Archibald and Mr. Thomas for the defense. State's here represented by Mr. Wood. Ms. Rawlings is here. Rachel Smith also for the prosecution. I believe Lindsay Blake was intending to appear by Zoom. Has she been let in or appearing? Okay, well, to the extent she can make an appearance there, we'll try to transmit this decision through the Zoom proceeding as well. The court would note as we get started here, there is an order governing courtroom conduct. I would ask everyone to please comply with that order, specifically as it relates to parts 2, C, and D regarding the use of cell phones or electronic devices, that there's no recording permitted throughout these proceedings, either audio or video. And please have your phones in either silent or off mode so that they don't interfere with any proceedings today. The court was here last week on motions filed just on the eve of trial from the defense. The court took under advisement motions in order to have time to make rulings today, which the court will do in an oral ruling. The motions that the court had under advisement were the motion to compel, which was filed by the defense March 7th, and the state's response March 13th. There was a rebuttal to that filed March 14th, and the court heard argument on that motion to compel. At this time, then, the court is prepared to make ruling on the motion to compel. In essence, the motion asked the court for an order compelling the disclosure of all information that was sought by the defense in a discovery request that was filed in the case on August 9th, 2021. Some procedural history there. There was an order appointing Mr. Archibald on August 6, 2021 as the attorney in this case. There was a first supplemental discovery disclosure provided by the state on August 9th, 2021, notifying the defendant of statements of the defendant. The disclosure also identified what was, quote, defendant's jail phone calls and visits. There was also responses as to statements of co-defendant, which also referenced, quote, defendant's jail phone calls and visits. and the defendant's prior records, and those have been previously provided to the defense on a July 15th, 2021 disclosure according to the state. The court considered the state's response to the request for discovery. There was a notification by John Thomas that the discovery in the above referenced matter was provided to co-counsel Mr. Archibald August 16, 2021 and November 22nd, 2021. In the hearing we had on March 15th, 6 days ago, the counsel for the defense stated unequivocally that the state on Monday, March 13th, had given the defense recordings of jail calls and visits, but also argued that there was no time to fully review those and investigate if anything needed to be investigated. As it relates just solely to the motion to compel, based on the request that any additional items be further disclosed through discovery, the court does find that the state did comply by providing the responses requested through the motion to compel. And so, based on argument and what was represented on the record, the court finds at this time it's not necessary to order any compelling further of discovery, as the state's indicated it's been provided. So the defendant's motion to compel is denied. And I'll mention to counsel, obviously, I've got quite a bit to say here today, and this will be oral rulings, which will be preserved on the record. We do have the court reporter here as well as the FTR recordings, and I won't be requesting any orders to be submitted from counsel. The court will take care of the orders that will flow from the rulings made today. The other motions court took under advisement was a motion in limine to exclude late disclosed evidence. The court has gone through that motion in limine to disclose the late disclosed evidence, and in lieu of an oral ruling on that today, the court is going to issue a written ruling which will address the specific items sought to be barred in the motion in limine, and a written ruling will be provided to the parties, should be no later than tomorrow on Wednesday, the 22nd of March. Final motion then the court will consider today is the motion to dismiss the death penalty. That was a motion filed on March 5th, 2023, and seeking dismissal of the state's notice of intent to seek the death penalty. That was filed in this case on May 2nd, 2022. The court did determine the notice was timely filed pursuant to Idaho Code 18-4004A. I'll just note at the outset too, I recognize a late filed motion to provide additional evidence to the court was filed yesterday. I'm aware that that's been filed, and I'll address that at the end of the decision that I've made here now. Going back procedurally then to the motion to dismiss the death penalty, the motion cites 4 bases in support of the argument to dismiss the death penalty in this case. Number 1, media saturation. Number 2, multiple discovery violations by the government. Number 3, an argument that the defendant's mental status should preclude the death penalty. And number 4, an argument regarding the inability of the state to effectively administer the death penalty if the jury decided to impose it. The state filed their objection to this motion on March 13th, 2023. The state argues the motion is not ripe, that media saturation is not a valid ground for the relief sought, that the alleged discovery violations do not warrant the relief sought, that capital punishment is a constitutionally available sentence in Idaho, and that the manner in which the punishment may be administered is not a ripe issue. The defendants then filed their response to that motion March 14th, the following day. So that was a week ago. Contained in the response was a supporting affidavit of Mary C. Goody, who is a defense team mitigation specialist on the defense team. In her affidavit, there were a couple of statements and comments in there. Paragraph 18, she says, quote, "The recent disclosures make reviewing the complete discovery information frankly impossible." Paragraph 19, quote, "Should this additional discovery be allowed, I would be further precluded from conducting my customary and reasonable mitigation investigation into Lori Vallow Daybell's case. Allowing in any of the state's new discovery after the discovery cutoff date prevents me from conducting the type of mitigation investigation which adheres to the prevailing professional norms of practices in death penalty cases." At the outset, this court has considered the arguments in the motion to dismiss the death penalty relating to media saturation, the defendant's mental health, and the ability or inability of the state of Idaho to currently carry out a death sentence. The court notes that also under advisement are motions challenging the constitutionality of Idaho's death penalty statute. Those arguments will be addressed subsequent to the court's analysis of the argument that late disclosed discovery in this case merits a sanction of the dismissal of the death penalty, and this decision will focus on that argument. The court will now review the argument related to the alleged discovery violations in this case. There's a pertinent timeline that the court's considered in the case. There was an indictment returned by a grand jury on May 25th, 2021. The defendant was arraigned on April 19th, 2022. The state timely filed a notice of the intent to seek the death penalty on May 3rd, 2022. Court sent out a
Y'all couldn't hear anything? So hold on. I think I know why. Okay. I was still playing this, but I was going to show pictures of JJ and Tylee. I didn't know that y'all couldn't hear if it wasn't on the screen.
There were disclosures made on February 27th, 2023, which were late in that the scheduling order expressly stated that the discovery had to be completed prior to February 27th. And there's a third category of disclosures which occurred in March of this year, which were inarguably late and past the February 27th deadline for discovery. The courts considered the argument of the state as it relates to that February 27th deadline. While the order is clear, the state argues that it was led to believe that the February 27th date was in fact the deadline. In considering this argument, the court determines that the disclosures made February 27th were in fact late, but considers the state's good faith explanation and mitigation when determining whether prejudice has resulted due to the time those disclosures were made. However, the court also must consider that additional disclosures were made well after the February 27th deadline and are inexcusably late. Notably, there were provided to the defense for the first time recordings of jail calls and visits, which include both statements recorded of the defendant and the co-defendant. Still pending out there also are potentially new DNA results, but the disclosures of those 100 plus hours, as it's been represented, of jail phone calls of the defendant and co-defendant were clearly past the deadline. So the court now must consider, pursuant to Criminal Rule 16E2, well, I'll cite a case here, which is State versus Matthews, 124 Idaho 806. And that says, pursuant to Idaho Criminal Rule 16E2, and I'll note that's now Rule F2, the rules have changed. The court is authorized to impose sanctions for discovery violations. See State versus Merrick, 112 Idaho 860, 1987 case. The choice of an appropriate sanction for failure to comply with a discovery request is within the discretion of the trial court, and the trial court's exercise of that discretion is beyond the purview of a reviewing court unless it has been clearly abused. And that's, again, the State versus Matthews case, 124 Idaho 806. Courts reviewed Idaho Criminal Rule 16K, which cites to orders for discovery. If a party has failed to comply with a request for discovery under this rule, the court, on motion of a party, may, number one, order a party to permit the discovery or inspection. Number two, prohibit the discovery of part or all of the information, evidence, or material sought to be discovered. Or number three, enter such other order as it deems just under the circumstances. So the court does have a statutory or a rule-based and case-based precedent for imposing any sort of sanction as a result of discovery violations. As an initial determination here, this court does find that there have been discovery violations in the case. The defense argues there have also been Brady violations. The court has reviewed the record and determines that at this time, there's no indication that the state has violated either Criminal Rule 16A, which requires mandatory disclosures, or Brady, as there's no evidence that tends to negate the guilt of the accused as to the offense charged, or that would tend to reduce the punishment of the offense. No evidence of that nature has yet been identified specifically. The problem here is a timing problem. The problem here is that both parties cannot be certain whether or not there is exculpatory evidence or mitigation evidence within the late disclosed discovery. The defense argues that they cannot review the late disclosed evidence because there's simply not enough time remaining before trial to do so. The state conceded at the hearing on March 15th that even the prosecution likewise would be unable to complete the review of all discovery before trial. The court cannot and will not engage in speculation that the late disclosed discovery does not contain any exculpatory or mitigating evidence. If the final discovery disclosures had been submitted by the state to the defense on February 27th, and that was the end of the disclosures, it would be difficult for the court to determine that prejudice would arise from potentially a one-day miscalculation. However, even more discovery, and a significant amount, was further disclosed even later. On March 7th, just 14 days ago, a motion to compel was filed by the defense requesting further disclosures of information previously requested by the defense going back to a 2021 filing. In response, the state produced a supplemental discovery disclosure on March 13th, 2023, producing those, what I'll refer to as jailhouse recordings. The parties have represented to the court that over 100 hours of previously undisclosed recordings were provided to the defense. The state concedes that this late disclosed discovery was due to, quote, an oversight within the offices. In order to determine if a discovery sanction is warranted, the court has to consider whether there is in fact now prejudice. A Brady or Youngblood is another case analysis is not required to reach that decision here, as the fundamental consideration is the right of the defendant to meaningfully prepare their defense and the duty of the state to comply with court-ordered discovery deadlines. As has been argued throughout this case, death is different. Here, the defense argues there is actual prejudice due to the late disclosed discovery and that it is substantial and material. The court has considered the arguments of Mr. Archibald. Mr. Archibald urged the court to consider that he typically receives discovery in a timely manner when dealing with the prosecution in other cases and does not have these discovery-related issues. And the court, based on my experience, I agree with that assertion. I've dealt with Mr. Archibald in hundreds of felony cases, including other murder cases. I can't remember a single case where Mr. Archibald filed a motion to compel or argued for a discovery sanction until this case. Mr. Archibald has established a pattern of credibility with the court that I consider when hearing his arguments that there is in fact prejudice. Likewise, this court has also dealt extensively with both Mr. Wood and Ms. Blake in hundreds of felony cases. And I find that both Mr. Wood and Ms. Blake are honest prosecutors and forthright in the duties they undertake as prosecutors, and I have no reason to question the integrity of the prosecution in this case. As has been demonstrated in this case, they've continued to disclose discovery even when they knew it was beyond the deadline because they have followed their ethical responsibilities in this case as they do in all of their cases, in my experience. Upon weighing the arguments of counsel and considering the record, the court must determine here that the defense has in fact demonstrated material prejudice resulting from late disclosures. The prejudice has occurred because of the proximity of the trial, the volume of the discovery, and the inability of the defense to adequately review that discovery before trial begins. In a case called U.S. versus Rivera Clemente, a federal court held that the failure of the government to fully disclose all discovery resulted in prejudice. The court further stated, quote, moreover, in a death penalty case where the stakes are so high, a smaller quantum of prejudice may justify a sanction. And that also cites a different case, Lopez Matias, 522 F3rd 154. Having determined that prejudice has resulted due to the late disclosed discovery, the court must next consider what course of action, if any, is necessary. First, with the defense having timely raised the issue, the court determines that if I were to fail to address this discovery issue, I believe this case would inevitably be reversed on appeal if there was a capital conviction. With the defense assertion of prejudice, the court must determine what is an appropriate remedy. Here, because the court has found or has not found any willful conduct on the part of the state, the court is not primarily concerned with any sort of sanction or punishment. What the court must address is an appropriate remedy to try to mitigate the prejudice that has been caused by the late disclosures. Ordinarily, a logical remedy would exist here, and that would be a continuance of this trial. This has been proposed by the state as one solution, and the state has proposed to mirror a continuance in the companion case of the Chad Guy Daybell's case, 1623 case. However, here, that's an option that I can't consider, because in this case, the defendant has unequivocally asserted her right to a speedy trial. In determining whether speedy trial is violated, one of the major factors is the reason for the delay. The reason for the delay here rests on the state and can't be counted against the defendant to justify a delay of her trial in this case. If I were to delay this case based on an issue caused by the state, I believe that would violate her fundamental and constitutional right to a speedy trial. On that issue, it's been brought up before, and I would caution the defendant that her attorneys have also cautioned her that by insisting on going forward with the trial now, knowing there's additional evidence they are not prepared to address, that's a risk. And the risk, I believe, has been discussed by counsel and by the defendant, and the decision as to whether or not to continue forward without a continuance is a decision only the defendant with the competent advice of her counsel can make. The issue's been raised before, and again, there's never been a waiver of speedy trial, so we're scheduled to start with jury selection next week, and that's when we're going to do this trial. The court sees then the remaining options then as either somehow sifting through this evidence to determine what should or could be excluded. I could also follow the defense recommendation of just carte blanche excluding significant portions of the state's case as a sanction, and I've considered that. The court also finds that given the statements of both the defense and the state, it would be impractical at this late stage, with trial starting next week, to be able to go through this evidence in a piecemeal fashion to determine what comes in or what would be excluded. There's simply not enough time to go through that exercise. The court also finds the defense request to exclude numerous witnesses and much of the state's evidence would be an unreasonably harsh sanction, denying the state of its right to bring the defendant to trial on evidence that's been previously disclosed. So that means there are two remaining options to consider: striking the death penalty or dismissing the case. The court determines that dismissing the case would again be too severe of a sanction here, given that the court finds the state has in good faith attempted to disclose all discovery, and with a clear determination here that the state has not acted in any way in bad faith. The court's considered further the state's objection as it relates to an argument that this issue is not ripe to be considered at this time, that perhaps the court should wait until a verdict comes in to determine whether or not the death penalty should still be instructed to the jury in this case. I don't find that to be a persuasive argument. I think it is a ripe issue that's before the court now and needs to be determined before trial begins. There's a case, I'll cite United States versus McGriff, 427 F sub 2nd, a 2006 New York case. It says, moreover, there are practical reasons weighing against the post-trial assessment to conduct a capital case only to strike the death penalty notice afterwards would be a colossal waste of time, effort, and expense for both litigants and the courts. Finally, then the court considers the defense argument that the death penalty should be stricken as a discovery sanction in this case. The court notes that it is the sole province of the prosecution to exercise their discretion in determining what charges to file, and in this case, whether a notice of intent to seek the death penalty under Idaho law is warranted. Being mindful of that, the court has sought to consider any other reasonable alternative to interfering with that prosecutorial discretion. As previously mentioned here, all other options have been considered before determining whether it would be an appropriate sanction to strike the death penalty. First, and again, the court would note that there's a heightened level of scrutiny and due process protection afforded a defendant in a death penalty case. The statement death is different has been cited many times by the defense in this case, and it is in fact a legal maxim coming out of a federal case called the Furman case. The U.S. Supreme Court summarized in some of these decisions another case called Sparkling versus Florida, and they noted that in post-Furman jurisprudence, continuing to recognize that, quote, death is different. In the 12 years since Furman, quote, every member of this court has written or joined at least one opinion endorsing the proposition that because of its severity and irrevocability, the death penalty is qualitatively different from any other punishment and hence must be accompanied by unique safeguards to ensure that it is justified response to a given offense. The U.S. Supreme Court has on occasion relied on this difference as the basis for upholding procedures in death cases that are not required in other cases. There's other sites that cite to a heightened fairness and heightened reliability standard that comes along with capital cases, and also a fairness in fact finding. And that would be, for example, the Reed versus Convert case. In that case, the U.S. Supreme Court held that, quote, in capital cases, the balance of conflicting interests must be weighed most heavily in favor of the procedural safeguards of the Bill of Rights. And in a different context, the U.S. Supreme Court in Gardner versus Florida held that due process was violated when the death penalty was imposed on the basis of a confidential informant, which was not disclosed to the defendant or his counsel. So the case law from the United States Supreme Court is clear that, in fact, death is different. The court here has to consider whether there is any precedent in Idaho for this proposed sanction. While the state of Idaho, well, there isn't in the state of Idaho. I'll just state I haven't found any case where this has been considered or ruled on. However, as I mentioned, the sanction has been recognized and upheld in other jurisdictions, including federal courts, and they've recognized it as an appropriate remedy. There are reported cases in other jurisdictions where courts have determined the striking of the death penalty to be an appropriate sanction. Notably, in the federal system, there's a different procedural mechanism required of the government to go forward with the death penalty, and this procedure differs from Idaho. Some of the federal cases detailing why the death penalty was stricken as a sanction explain a failure of the government to comply with that procedure. In those cases, the court discusses a showing of prejudice as a threshold, quote, to bar the government from seeking the death penalty. And that's from a case U.S. versus Rivera Clemente. The rationale, however, behind both that federal procedure and the issuance of a sanction would apply to this case. Some of the quoted language from that United States versus Rivera Clemente case, which is cited DPR September 19th, 2012, that stated that part of the citation there, we agree that the prosecutor's failure to provide timely and full disclosure of all statements has caused prejudice to the defendants. And then they stated that in a death penalty case where the stakes are so high, a smaller quantum of prejudice may justify a sanction. And in that case, the sanction was the striking of the death penalty. In this case, the trial court here, I'd cite to a case, State versus Morales, which is a Connecticut case, 232 Connecticut 707, a 1995 case. The trial court should not be faced with the Hobson's choice of either dismissing all criminal charges or denying any relief whatsoever to a criminal defendant who possibly has been prejudiced as a result of the negligence of the state. Instead, the trial court should determine the appropriate remedy in an exercise of its discretion. And then quoting another case, State versus Tiedemann, 162 P3rd 1106, which is a Utah case, the touchstone for the balancing process is fundamental fairness. If the behavior of the state in a given case is so reprehensible as to warrant sanction, a sanction might be available even where prejudice to the defendants is slight or only speculative. If prejudice to the defendant, on the other hand, is extreme, fairness may require sanction even where there is no wrongdoing on the part of the state. In between these extremes, we have no confidence that trial judges can strike, or we have confidence that trial judges can strike a balance that preserves defendants' constitutional rights without undue hardship to the prosecution. So that case says to look at weighing out the balance of prejudice versus any misconduct of the state. And again, I haven't found here any misconduct of the state. However, procedurally, disclosures were late and deadlines were missed. On weighing the facts of this case then against the rights of the defense to have an objectively reasonable time to prepare for a death defense, the court determines that the late disclosure of discovery has materially prejudiced that right. The court also notes that this is not the result of a single discovery violation, but rather the cumulative effect of a deluge of discovery coming too close to trial, culminating in a large discovery disclosure a day after the scheduling order mandated, and finally even more discovery that was not provided to the defense until, according to the record, March 13th. The defense cannot be required to review that quantity of new discovery only 2 weeks before jury selection begins. This has prejudiced the defense. I've cited the affidavit of the mitigation person who has said unequivocally they simply cannot have time to prepare and go through for mitigation the late disclosed discovery. Thus, considering everything, the court is required to fashion a remedy that honors the rights of the parties, the fundamental right to a fair trial, and the right of the state to bring to trial those who are accused of a crime. In balancing these rights, the court concludes here that as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at trial, and the state's May 2nd, 2022 notice of intent to seek the death penalty will be stricken. To be clear, the court does not impose this sanction to penalize the state, but rather to ensure the constitutional right of the defendant is protected, allowing for a reasonable defense to be prepared for this trial. In addition, this court will keep under advisement any further objections that may be lodged in the form of motions in limine that would come either before or during trial to consider whether any late disclosed evidence should be excluded in an attempt to remedy the prejudice that may have resulted from these late disclosures. Finally, a couple of points on that decision. There was a late filed emergency motion yesterday that related to this. The court had reached this determination and determined this to be the appropriate remedy prior to reviewing that, and in fact did not consider any of the issues raised in yesterday's pleading and making this determination, and I'll consider that pending motion moot. I'll also note that the ruling.
Okay, y'all, let's cut this out. Okay. He is very monotone, honestly, and it's hard for me to even. What we know he's saying basically though is the defense mitigation officer doesn't have the time to go through the evidence because it was turned in late, basically, and because she waived her right to a speedy trial, or she did not waive her right to a speedy trial. Her trial will start next week, and there's no way. So it seems like the state, the prosecution has had this evidence for how long now? How long? We are mesmerized to sleep. So they've had this evidence for like a year or two, I don't know. And the defense is supposed to get it a month before trial starts and be able to go through all of it. They can't, obviously. And he said the only option they have here is to, I think he said, to dismiss the whole trial, to dismiss it, or to take the DP off the table. I mean, I guess this was the best bet, I guess, but still, I don't like it. All right, we're going to go through a little timeline really quickly, I think. All right. This is 2006, happily married. Before all the notoriety, Lori married a businessman named Charles Vallow. Friends say it appeared to be a happy marriage. Together, the couple was raising Tylee Ryan, Lori's daughter from a previous marriage. Happy hump day! 2014, JJ joins the family. Lori and Charles Vallow adopted JJ Vallow. He was the grandson of Charles' sister. So JJ was not her son. He was her nephew by marriage. Hold on. All right, let's see. Okay. No, he was the grandson of Charles's sister. So JJ was not biologically related to Lori. JJ had autism, and April Raymond, who was Lori's friend, says Lori was patient and ideal mother for him. Beja, somebody, met the Vallow family when they lived in Arizona. She says Tally embraced her role as big sister, that Tally even jokingly referred to JJ as her own child. Aww. 2017. Sometime around 2017, relatives say Lori's relationship with her children changed. Her friends say she had been reading books of doomsday by author Chad Daybell. Daybell, who wrote several fiction books about preparing for the end of the world, lived outside of Rexburg, Idaho. In 2018, Lori meets Chad. Sometime in 2018, Lori Vallow met Chad Daybell. Lori's friends says there was a connection between the two, and they began doing religious podcasts together. Daybell was married. Together with his wife, Tammy Daybell, he was raising 5 children. Lori's friend, Melanie Gibb, would later say she heard Chad and Lori talking about zombies, peoples whose souls were replaced by dark spirits. Lori's former friend, April, told 48 Hours that Lori started referring to her husband, Charles Vallow, as a demon. In 2019, Charles Vallow became worried about Lori, and he went to the police with his concerns. He told them Lori believed she was a god preparing for the end of days. He also said Lori had threatened to unalive him. Yes, Lori did have an older son as well. Charles Vallow filed for divorce from Lori. In court documents, Charles expressed that he feared for his and his children's safety. July 2019. Charles Vallow went to the house where Lori was living with the children in Chandler, Arizona. Charles was supposed to drop their son JJ off at school. But when he went inside the home, Charles was unalive by Lori's brother, Alex Cox. Cox told police that Lori and Charles got into a fight. Alex claimed that he was protecting his sister and unalive Charles in self-defense. Lori and Tally, who both say they heard the shooting, told similar stories of self-defense. September 2019. Lori Vallow moved closer to Chad Daybell. She relocated the kids to Rexburg. Lori's brother, Alex, moved into the same apartment complex. Lori, Tally, JJ, and Alex went to Yellowstone National Park. Police say that is where the last known photo of Tally was taken before she vanished. Melanie Gibb had said that Lori had referred to Tally as a zombie. September 9, 2019. The morning after Tally's disappearance, investigators say that Alex Cox's cell phone GPS placed him at Chad Daybell's backyard on the property for about 2 hours. About 14 minutes after Cox's GPS showed him leaving the property, Chad Daybell texted his wife Tammy. The text read, "I spotted a big raccoon along the fence. I hurried and got my pew-pew. He was still walking along. I got close enough. One pew did the trick. He's now in our pet cemetery." September 22nd, 2019, JJ Vallow disappears. Police say JJ was last seen September 22nd, 2019. Melanie Gibbs said that her and her boyfriend, David Warwick, were staying with Lori in Rexburg that weekend. On the night of September 22nd, 2019, Warwick says he saw Alex Cox carrying JJ into Lori's apartment. But the next morning, according to Warwick, when he asked to see JJ, Lori reportedly told him that JJ was being a zombie and that Cox had to take him away. September 23rd, the day after JJ was last seen, investigators say that Cox's cell phone showed Cox return to Chad Daybell's backyard. This time, Cox was there for about 17 minutes. Wow. October 19, 2019. With Lori Vallow's children's whereabouts unknown, tragedy struck Chad Daybell's family. Daybell's wife, Tammy, passed away. The couple's son, Garth, said that Tammy passed away in bed and that he and Chad called 911. The Daybell children told 48 Hours they declined an autopsy. They say the coroner told them Tammy's passing appeared to be natural causes. They believed that because their mom was in ill health prior to her passing. November 5th. Roughly 2 weeks later, Lori and Chad got married on a beach in Hawaii. Later that month, JJ's grandmother, Kathy Woodcock, asked police to check on JJ's welfare. Woodcock said she was concerned because she hadn't heard from JJ in months. Rexburg police went to Lori's house looking for JJ. Police said Lori lied to them, claiming that JJ was safe and staying in Arizona with her friend Melanie Gibb. At first, Gibb wasn't forthcoming about JJ's whereabouts, but later called the police and told them JJ had not been with her. Sorry. Hello. Okay. Bye. While Rexburg's police attempted to locate JJ, investigators soon realized that his sister Tally was also missing and launched a nationwide search for the children. While investigators searched for the missing children, Lori and Chad traveled back to Hawaii. In December 2019, Fremont County Sheriff's investigation grew suspicions about Tammy Daybell's death, and they exhumed her body to conduct an autopsy. The same month, Lori's brother, Alex, passed away in Arizona. It was determined that he passed away from natural causes. January 25th, 2020, authorities served Lori Vallow Daybell an order requiring her to produce her children. After failing to comply, Lori was arrested in Hawaii. 2 weeks later, she was extradited back to Idaho. Even after Lori's arrest, the couple refused to say where the children were. On January 9, 2020, the FBI, Rexburg Police, and Fremont County Sheriff's Office descended upon Chad Daybell's home and property. Authorities dug in areas of the backyard where Alex Cox's cell phone had pinged in September 2019. Tragically, they uncovered human remains buried in shallow graves. JJ Vallow had been buried under a tree about 50 yards away. Investigators found Tally's grave in Daybell's pet cemetery. Prosecutors believe she was buried in the same location Chad Daybell's referenced when he texted Tammy Daybell 9 months earlier saying he was burying a raccoon. Investigators dug up part of the pet cemetery and found no raccoon. But Daybell's family told 48 Hours there was a second pet cemetery on the property that was not searched. Chad Daybell was arrested. June 2020. Authorities later confirmed that they had identified the remains of JJ Vallow and Tally Ryan. A memorial was built along the Daybell fence to honor the victims. Chad Daybell and Lori Daybell were charged with first-degree unaliving for the unalivings of JJ and Tally. Daybell was also charged with unaliving his wife, Tammy. June 2021, Chad Daybell pled not guilty to all charges. Lori Vallow Daybell was also charged with conspiracy to unalive Charles Vallow. The same month, a judge ruled Lori incompetent to stand trial while she receives mental health treatment. She had not yet entered a plea, and her case was on hold. August 2021. Prosecutors announced they will seek the DP against Chad Daybell. Daybell is jailed awaiting trial. September 2021. Chad and Tammy Daybell's children speaking publicly for the first time together. They told 48 Hours they believe their father is innocent. I have the hiccups. Daybell's daughter, Emma Murray, says she believes Chad was framed by Alex Cox and Lori Vallow Daybell. Wow. April 11, 2022. Judge Stephen Boyce ruled Lori Vallow Daybell is now mentally competent to stand trial in the Idaho murder unaliving case. He did not provide other details about her treatment or mental condition. She is scheduled to be formally arraigned in court next week, but both Lori and Chad Daybell are set to stand trial together early next year. Somebody scare me. I have the hiccups. Lori Vallow Daybell refused to enter a plea to unaliving and other charges, prompting Judge Stephen Royce to enter a plea of not guilty on her behalf. Lori Vallow Daybell and her husband Chad Daybell were both at the courthouse in the eastern Idaho town of St. Anthony for court proceedings. Lori Daybell for an arraignment that was delayed for months while she underwent treatment at a mental health facility, and Chad Daybell for a hearing over the trial venue. May 4th, 2022. Lori Vallow Daybell would qualify for capital punishment if she is convicted at her trial later this year because the slayings were exceptionally depraved and carried out for financial gain, according to court documents filed by prosecuting attorneys from Fremont and Madison County on May 2nd. Attorneys for Lori Vallow Daybell asked a judge to send the case back to the grand jury because they say that the conspiracy charges are oddly constructed and could confuse the jury. Daybell and her husband Chad have pled not guilty to unaliving, conspiracy, and grand theft charges in connection to the unaliving of 7-year-old JJ and 17-year-old Tylee. 7th District Judge Stephen Boyce has banned cameras from the courtroom in the criminal case of Lori Vallow. Chad Daybell saying he fears the images could prevent a fair trial. The Idaho judge said news organizations will no longer be able to shoot still photography or videos inside the courtroom. January 7th. Judge Stephen Boyce rejected a request from Lori Vallow Daybell's attorneys that she and her husband be allowed to meet in person and on the phone to discuss strategies and settlement options. Attorneys for Vallow Daybell and Chad Daybell presented several requests during a motion hearing, including that the trial be delayed until 2024, a request from Chad Daybell's attorney, and that the death DP be taken off the table, a request from Lori Vallow Daybell's attorney. Judge Stephen Boyce granted a motion by Chad Daybell's attorney to sever the trials, meaning separate trials will be held. Lori Vallow Daybell's trial is scheduled to start April 3rd. Chad Daybell's trial has not been scheduled. March 21st. Prosecutors were seeking the DP for both defendants, but Lori Vallow Daybell's attorney said it should be taken off the table because because they will have no time to fully review a large amount of evidence that was turned over in recent weeks. During a hearing, Judge Stephen Boyce agreed. He noted that Vallow Daybell has not waived her right to a speedy trial, so the proceedings could not be rescheduled to give her defense team ample time to review the evidence. The DP still applies to Chad Daybell's case. Okay, I did it. I held my breath. I swallowed 3 times. Keep our fingers crossed. Okay, so still okay. There's so many things that I feel that's wrong with this case. The fact that like this should be on TV. The camera should be allowed in there. I don't know. There's a lot of people in the comments saying like somebody should investigate the prosecution and this judge because they are just doing everything. The prosecution team is responsible for not complying and doing their due diligence as required. I've said this before. but the prosecution team is not strong enough to try this complex situation. They need a bigger team and sharper attorneys to get the job done. The prosecution brought this on themselves through their incompetence. I disagreed with several of Judge Boyce's rulings, but in view of the discovery violations, this was his only recourse. Otherwise, a guilty verdict would go up on appeal and she would definitely prevail. I sure hope the judicial system in Idaho learns from its mistakes here and does not F up the Kohlberger case too. Yes. Okay, so bend over and drink water. Can I drink a Red Bull? Okay, y'all. I'm gonna get with my friend about prison makeup, and as soon as I can, we'll do prison makeup on Facebook. Okay. Coffee. My friend, she don't wear makeup, but I'm sure she can tell me all the tricks and trades. So we'll do prison makeup for Facebook. Coming soon. Never seen me with the hiccups. It's terrible. I gotta bend over and okay. We're gonna end this one because I'm going on an hour, but let's see if we can do this. I don't know. Let's see if that works. Okay, you guys. Drink water from the. Everybody knows these little tricks and trades. Okay, drink water from the opposite end of the cup that you usually drink from, kind of upside from the opposite. How's it coming out? Yeah, this way. I don't know. Jamie, are you messing with me right now? Okay, y'all. So, anyways, Sean was off today, and I thought I was going to get a bunch of work done, but we had to go get all my daughter's stuff, the bedding and all her stuff. Mind you, my arm and neck is messed up. I lost all my nails in the process of bedding and all of this stuff, and I messed my neck up even worse. I'm in pain times 10. So pray for me. But I'm not going to call it a day. Bend over and drink the liquid. Silly. Bend over, drink the liquid. I did. I bent over and drank it. What do you mean? Bend over? I did. Forward or backwards? Which way? I have an appointment with the I go to physical therapy Monday, and I told them, I said, I don't know if I should go to physical therapy because I don't know what's wrong with it. And they said, well, we'll check you out. We can even order for an MRI. And we can also set you up with a orthopedic doctor. So just go ahead and call them. So that's what we do. Y'all. The hiccups are gone. Bending over and drinking my Red Bull work. And Sherry, I have to give you a shout out because you sent me the money to get my nails redone, and I appreciate that so much. I really do. You messaged me and was like, $50 for your nails. Thank you. Yeah, I love to have my nails done, but people's broke these days. Can't afford it. YouTube ain't paying nobody. So Sean's actually in the house trying to get that figured out right now. That's why he called. He needed me to allow him to enter into my YouTube stuff. So I think they're gone. But anyways, you guys, I'm gonna keep up with this. It sucks that cameras are not allowed in. I think they should be. I absolutely think they should be. Transparency for these trials I think should happen. But anyways, things are going to be coming out in the next few weeks, I'm sure. We'll keep up with it. So you guys let me your thoughts in the comment section below. His only option, I personally feel like the prosecution they messed up on this one. Now, the judge said, like, per Nate, he was like, he's the judge isn't faulting the prosecution. I am. They should have got this done way earlier, in my opinion. So I don't know. You guys let me your thoughts in the comment section below. Subscribe to the channel if you haven't yet. I love you guys, and this is not the last one. We will be going live more over here, and I'm going to try to do a couple over on the Bass Chat, even though I messed it up and it's no longer monetized for some reason. We're still going to do our lives over there. So you guys, leave me your thoughts. I love y'all, and I'll see you guys back here in a little bit. Bye.